Do you have any business here?
We do.
What's your business?
Video recording. Yes.
You have
So
to have
I'm gonna need
business.
I'm gonna need your
Business.
supervisor, please, because this is business, sir.
He's on his way.
Okay.
I need your ID real quick.
Am I being detained, sir? Do you know who auditing America is? I suggest
Well,
you do the right thing.
I can trespass you, so I need
For what
I
crime?
need to know.
For
well,
what
because they said you're refusing to leave.
Well, you have to do an investigation. You can't just go by what they said. I have the right to be in a public
Well,
place.
They called.
Okay, anyone can
So,
call. Sir, loitering.
loitering.
Sir, I'm working. This video generates revenue, which gets taxed.
You have to have
No, I don't.
business at the business.
Well, I am. No, they said that we
You're
can't.
causing them to be alarmed by your actions. That's
Well, I'm not. No, no,
asked all
no. How is that? Specifically, how is another person's actions my fault? They don't care about my Fourth Amendment.
Well, that's something you'll want to take up with them in court.
No, we don't have to go to court. Why would we need to go to court? We're gonna go ahead and leave under threat of arrest, okay? Threat of arrest. And you, my friend, are gonna be on the internet forever.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, investigations, etc. And here in this video, we have the dreaded loitering statutes that we commonly see law enforcement employing use all over the nation, really. And what we have here is we have an auditor by his own admission, right? We have First Amendment auditor. We have somebody that is recording everything they can see in public, to include staff. And from the basis of what we can see here, it looks like the staff got upset, so they notified law enforcement. Law enforcement showed up, and now law enforcement it seems like attempting to levy loitering statute to make a nexus from loitering to criminal trespass. And that appears the nexus that they are looking to utilize enforcement powers. And that's just based upon my training experience and what they're actually stating here. So let's go through the case law. Let's kind of flush this out, because I know we've talked about loitering in the past, but I'm going to kind of break down loitering a little more for those of you that may not understand all the nuances behind it. So the first thing I want to talk about is the stop and ID, the detainment aspect. We have clear Supreme Court case precedent on this, right? Brown v. Texas, 1979. The Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion in order to detain and compel somebody to identify themselves. Again, Brown v. Texas. And so we have that aspect. It's a reasonable suspicion of a crime. And so it looks like the crime nexus, again, is going to be loitering. But before we get there, the initial cause of the call was for him exercising his freedom of speech, him exercising his right to record. So let's just kind of flush into that a little bit. As many of you guys know, we talk on this channel a lot, flag burning statute, and again, that's Texas v. Johnson, 1989. And the reason why this is important to mention is because it was kind of mentioned in this video about him talking about somebody else's perceived subjective view of his video recording, right? So this is a 1989 case, right? The Supreme Court has held that flag burning constitutes symbolic speech that is protected by the First Amendment. The Supreme Court further held that the freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for suppressing free speech. And so again, that's important because the fact that somebody does not like somebody else's freedom of speech, the fact that somebody is upset with somebody exercising their freedom of speech is not justification for the suppression of that speech. And the people who would be doing the suppression in that case, most likely, especially in 2025, are going to be law enforcement. And so I make it very clear when I do my instructions and when I talk about this, I make it very clear that as law enforcement, you have to be very careful that you're not infringing on somebody's constitutionally protected rights. And just because you find it offensive or your RP finds it offensive, that alone doesn't justify carte blanche suppressing it. And we have Supreme Court statute on this. And a lot of police officers have never heard of Texas v. Brown. A lot of police officers have never heard of Brown v. Texas. A lot of police officers have never heard of the statutes or the Supreme Court case precedents, I should say, the United States Supreme Court case precedents that we're going to be talking about today. And I think that's unfortunate. The next one I want to bring up, as you can see here on your screen, Cohen v. California, 1971. It says states must have a better reason than a concern for general disturbing the peace when they ban displaying an expletive in a public space. And so the reason why I say this is because, according to Cohen v. California, according to the Supreme Court, you can't take enforcement action on somebody for disturbing the peace when they're cursing, right? Displaying a curse word, telling a police officer to go F himself, or using explicitives, right? The Supreme Court has made it very clear that there has to be a better reason than he's cursing, right? And so I think that's super important that we realize this, because in this case, right, the Supreme Court has said cursing in public is permissible, right? And so now we have to weigh, again, and I know this is hard for a lot of people, the common sense aspect of it, right? So as a law enforcement officer, let's really dig into the common sense aspect of it. So if the Supreme Court, United States Supreme Court, has said this person can curse at you in public, and you would need a better reason than him cursing at you to take enforcement action, what makes you think him holding a camera not cursing rises to the level that you need to take enforcement action? Again, let's just common sense standpoint, right? Because cursing at somebody, right, could make somebody not want to be there, right? I would think that you would have a better argument for your workers, your city employees, if they're being cursed at. If somebody was cursing at them, I think that you would have a better, cause, to at least try to figure out what's going on. But the Supreme Court has made it very clear, right, that you got to do better than that. So if you have to do better than that when it comes to cursing, how is this going to rise to the level that you're going to create a nexus for that? Honest question, law enforcement. Again, it's an honest question. This is something that I usually go over as a scenario in my courses, because we have to be realistic. We have to really attempt to abide by the jurisprudence that's out there, at a minimum. So again, the Supreme Court case presses is very clear. You can curse in public. You can show curse words in public. So how are you going to make this a legal justification through a nexus for a criminal trespass? I don't know. Okay, now let's move on to loitering. So let's look at some of our loitering Supreme Court case precedents. So the first one we're going to look at is coming from Jacksonville, Florida. Again, the United States Supreme Court held that a Jacksonville vagrancy ordinance was unconstitutionally vague because it did not provide fair notice of forbidden behavior and it encouraged arbitrary arrests and convictions. Okay, that's the Jacksonville case, Supreme Court case precedents, 1972. So the Supreme Court essentially held, and please don't believe your lying eyes, look it up for yourself, but the Supreme Court said, hey, this is a vagrancy ordinance. This ordinance is unconstitutionally vague, and it doesn't provide fair notice of what behavior somebody can and can't do. It looks like you're just arresting homeless people, right? It looks like you're just arresting people because they're homeless and they're here, right? And so again, the Supreme Court said, nope, can't do it. The next one we have is loitering statute out of Chicago. So you have City of Chicago v. Morales, 1999. The Supreme Court held that a law cannot be so vague that a poor person of ordinary intelligence cannot figure out what is innocent activity and what is illegal. Therefore, it overturned Chicago Municipal Code 8-4-015 loitering. Again, City of Chicago v. Morales, 1999. This is a good case to look up too, because the reason why Chicago enacted this municipal code is because they were having a lot of gang violence, which I think Chicago is, there is a lot of that activity that happens in Chicago. So to kind of curb this behavior, basically when they saw a bunch of males congregating in an area, this was a statute they could use to disperse. Like, no, hey, this is now loitering, we need you to disperse. And so I believe they were doing so, trying to benefit and trying to bring crime down. But again, just because you have good intentions doesn't mean you can violate people's constitutional rights, right? So the Supreme Court then came and said, hey, a law can't be so vague that a person of ordinary intelligence can't figure out what activity is legal and not illegal. And so what does that have to do with this case? Well, in this case, hypothetically, right, if I was arguing this, I'd be like, well, officer, I don't believe this meets the prerequisites for loitering. I would cite City versus Chicago v. Morales and be like, according to Texas v. Johnson, and Cohen v. California, I absolutely have the right to express and exercise my First Amendment activity, to include cursing if I wanted to. I'm not cursing. The Supreme Court says that I can be in public and I can lawfully exercise my First Amendment activity. All I'm doing is this. right? California v. Cohen states that I can curse at you if I wanted to. I'm not doing that. All I'm doing is this. And so you are attempting to criminalize me holding a camera up. I don't see, and I believe I'm at least of ordinary average intelligence, I don't see what activity I'm doing is illegal, because the Supreme Court case precedents, and I've looked this up, has absolutely protected this activity. So the nexus to loitering, I don't believe is constitutionally, would hold up to judicial review, as we see in Mayberry versus Madison. If you need to arrest me, go ahead. I'm not going to impede you, I'm not going to impede you in, blah, 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 right? And everybody has their own thing and what they're willing to do, how far they're willing to go. And it seems like this person was not, willing to take the ride. But again, I think that if you were to get arrested, right, if you were to stick to your guns and say, okay, well, you're going to have to do what you're going to have to do. I don't consent to any searches and seizures of my person, but I'm not going to prohibit you. I'm not going to prevent you from violating my rights. Click, click. You get taken downtown. I do not believe, based on my training experience in the case law precedent that we've seen here, that anybody would be able to, that would pass judicial review at the slightest. Because again, this would be an overly vague activity. Absolutely. The Supreme Court, again, has made it very clear that you have the right to do many things in public, to include burning an American flag. I think this person doing this is a lot less, if we took the common sense standpoint, this is a lot less intense, a lot less aggressive than burning the American flag and cursing. Again, law enforcement doesn't know what they don't know. Again, I encourage you guys, do ride-alongs and ask them, do you know what these case laws are? I guarantee 99% of officers have no idea. And, we can blame that on the system. We can blame that on their lack of education. We can blame it on a lot of different things, and that's fine. Tell me in the comment section below. But the truth is they just don't. So that's the reality. And so we have to address reality, because that's where we're at. So I hope this video was helpful for you guys. If you guys like this video, please like, share, subscribe. But what I want to hear what you think in the comment section below. Tell me what you think about loitering laws. Tell me what you think about the Supreme Court. Did the Supreme Court get this right? Did they get it wrong? I'm interested to know what you have to say in the comment section below. Hope you guys liked the video. And always, remember guys, always, long live the Republic.